Welcome to our first Constitutional Roundtable for this academic year on the City of Toronto versus Ontario decision of the Supreme Court of Canada. This webinar is being recorded and the link will be shared in the coming days. Our panelists will talk for about 60 minutes and there'll be approximately 20 minutes or so for question and answer following their discussion. Please use the Q&A function to submit your questions at any time throughout the discussion. I want to start by acknowledging the land on which the University of Toronto Faculty of Law operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit River. We also acknowledge that Toronto is covered by Treaty 13 and the Williams Treaty. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. We are joined today by our panelists. Geetha Philippopoulou is an associate at Goldblatt Partners, LLP. She was called to the bar in 2018 and is a graduate of U of T and an alumna of the Asper Center Clinic. Geetha practices employment law, civil litigation, and class actions. She's been involved in a number of constitutional and public law cases, including the City of Toronto and Ontario, where she represented the Canadian Civil Liberties Association, and V. Morris, where along with Nader Hassan, she represented the Asper Center. Lorraine Weinreb is now Professor Emerita at the Faculty of Law at U of T, where she has specialized in constitutional law, constitutional litigation, and comparative constitutional law. She assisted the Asper Center as an academic consultant on our intervention in this case. Alexi Wood is a founding partner of St. Lawrence Barristers, LLP. Alexi is an adjunct professor at the faculty, where she teaches in both the JD and LLM programs. Her passion for social justice and commitment to pro bono work began prior to entering private practice when she was the National Security Project Director for the Canadian Civil Liberties Association. She represented the Asper Center in the City of Toronto v. Ontario case at both the Ontario Court of Appeal and the Supreme Court of Canada. And our panel today will be moderated by Alexi's co-counsel at the Supreme Court, Liliane Kadia-Shaw. Lil is an associate of St. Lawrence Barristers, LLP. She was called to the bar in 2018 and currently maintains a broad civil litigation practice. Prior to joining St. Lawrence Barristers, Lil served as law clerk to the Honorable Madam Justice Karakatsanis of the Supreme Court of Canada. She completed her articles at the Ministry of the Attorney General Constitutional Law Branch and summered at Parkdale Community Legal Services. So I'm going to turn it over to Lil to moderate the panel.
Thanks so much, Cheryl. So I'm going to provide a brief introduction to the case before turning it over to our panel of experts to explain the significance of the Supreme Court's decision. So by way of a little bit of background, the City of Toronto used to have 44 wards, and each ward would elect a councillor who represented that ward's interests on City Council. By 2016, the City of Toronto had increased that number to 47 wards. They had extensively researched the best number of wards for the city and concluded that it should be increased from 44 to 47. So in May 2018, they proceeded with municipal elections, and the city opened nominations for candidates. The nominations closed at the end of July, and on the very same day that those nominations were closed, the province of Ontario announced that it would be introducing legislation to reduce the size of Toronto City Council from 47 wards, which is what it was previously, to 25 wards. The legislation was called the Better Local Government Act, but we'll just refer to it as the Act to keep things simple today. And the Act did extend the nomination period for candidates to mid-September, but elections still proceeded at the end of October. Before the elections could proceed, the City of Toronto and two private individuals immediately applied to the courts on an urgent basis to challenge the constitutionality of the Act. They argued that changing the ward structure mid-election violated their constitutional right to free expression under Section 2B of the Charter and violated the unwritten constitutional principle of democracy, which included a right to effective representation. They were successful before the application judge, but the application judge's decision was stayed, which meant that the elections proceeded in October based on the 25 ward structure. This issue ultimately went to the Court of Appeal, who released their decision a year after the elections took place. The Court of Appeal was very divided, with 3 judges holding that the act was constitutional and 2 judges holding that it was unconstitutional. This finally went to the Supreme Court, who released their decision last month. And the Supreme Court held that ultimately changing the ward structure mid-election was constitutional, but it was a very close decision, with 5 judges saying that the act was constitutional and 4 judges saying it was unconstitutional. So I'm going to turn it to our panelists to explain what the court said and what it means for the future of constitutional litigation. So I'll open up the floor to our panelists with a broad question. What does the Supreme Court's holding in this case tell us about Section 2B's protection of freedom of expression? Lorraine, do you want to get us started?
Sure. I think that this case is, in a sense, a revolutionary case, because on almost any law that the different levels of the judiciary looked at, there was a lot of established precedent, and this case sort of moves the weight of that precedent, and we don't know how significant that will be in the long run, but it's certainly true in Section 2B, because this Section 2B, under the traditional purposive motive interpretation, was very substantive, very principled. It was related to individual self-fulfillment, social development, progress, and also the most importantly for this case, the vitality and legitimacy of political speech in a democracy. And so we see here in the majority judgment of the Supreme Court, a de-emphasis on a purposive interpretation, which has in many, many cases emphasized that at the core of 2B is political expression and the opportunity to participate in the political process. And of course, there's nothing more central to those elements than an election. And so the orientation of the analysis is away from the Irwin-Toy test, which embodied those ideas and made it quite easy to prove a breach, and shifted it to this idea of the application of the Baer test, which leads us down to much more technical analysis of positive and negative rights, which we'll, I think, discuss in more detail later. So I think that it, just for freedom of expression and the interpretation of one express right in the Charter, we have one of the strongest rights that almost always produced a finding of a breach and Section 1 analysis, with the government's onus, of course, of justification. Here we see something radically different.
Thank you, Lorraine. Alexi, do you want to expand on that?
Sure, yeah. So I completely agree with Professor Weinrib on that analysis, and the fact that one of the most fundamental things from this decision is the shift away or shift towards the positive and negative rights analysis under Baer. And that was something that started at the Court of Appeal and then continued on through into the Supreme Court. And there's a very strong dissent from Justice Abella on this, really focusing on the specific point. And what's so important from this case is it is a precedent-setting fundamental case, because this case has now established that when looking at 2B, we are to do this positive negative rights analysis that was under the Baer test, which will be a full shift in how we approach Section 2B litigation going forward. And it's, as I said, there's a very forceful dissent from Justice Abella, who has very strong thoughts about the positive and negative analysis. As Professor Weinreb said, we'll be getting to that in some more detail later. But when we were approaching this case and going up to the Supreme Court, there was a discussion amongst counsel about what the court could do with this. And going into these types of cases, the court you never know how the court's going to take it. The court could have done a very narrow analysis just on the legislation, but they did take the opportunity to make a very strong pronouncement about how Section 2B is to be analyzed going forward. As Lil said, it was a close call, 5-4, but this is the framework that we have now been told we are to use going forward. So it was a very important case in terms of charter jurisprudence and charter litigation going forward, leaving aside the fact that it was a pronouncement on the legislation that was at issue for the municipal elections for the city of Toronto. So there's a fact-specific issue that's super important, but then there's also this broad picture of how we're going to deal with Section 2B of the charter going forward.
So what do we make of the Supreme Court's focus on the Baer test? And before you answer that, maybe for the benefit of our audience, we can briefly explain the distinction that we're creating between the Baer test and the Irwin test. And what does this Supreme Court decision tell us about those two tests, when they apply, and why there's a focus on the Baer test in this case?
I can get us started on that. So I think the division between the courts below on this issue, on the entire case really, has turned on whether the judge applied the Irwin-Toy test or applied the Baer test. And that's really because there was such a weak Section 1 justification advanced by the government. And so it became so important, are you going to apply the test which requires sort of a substantial interference, or which is the Baer test, or are you going to apply a test which finds a breach at the point of there simply being an interference with freedom of expression? And I think in the majority's decision that they actually have both expanded the application of the Baer test, but they've also changed it in a way which makes it in some ways simpler. So they have expanded it by saying that it applies beyond claims of under-inclusion. So previously, the Baer case, of course, is this decision about school trustees who were prevented from running for school board elections if they were teachers. And it comes from the Dunmore context, which arose in the situation of agricultural workers being excluded from a labor relations regime. And so the position advanced by the city and the applicants was that Baer is restricted to situations where there's a particular group which is being excluded. And what the court says in this case is that no, it applies to all 2B claims, as Alexi said, and you have to conduct this analysis of whether the applicant is seeking a positive state action or seeking to be protected from state interference, which would be a negative right. And so that statement is very clear from the majority that it applies beyond claims of under-inclusion. I would say that they've also changed the test because, they state the test at paragraph 23 of the majority's decision, and they go through this. I find it incredibly complicated, and I'm not actually aware of a 2B claim which has succeeded under the Baer test. I think it was actually impossible for a 2B claim to succeed under the Bayer test, because the first step is whether the claim is grounded in freedom of expression rather than access to a particular statutory regime. And then the second step is whether the claimant has demonstrated that lack of access to the statutory regime has the effect of a substantial interference with freedom of expression. And I think there have been articles written about the fact that these two questions are at cross purposes. And if you succeed under number one, you can't succeed under number two. And I think what the majority does at paragraph 25 is they kind of simplify it and they come out and just say, can you establish a substantial interference? And I think that does in some ways make it easier to understand if this is the test that we're going to have as practitioners, how are we going to apply it? And one positive thing which I would say about the majority's decision, which I had to search very hard to find a positive thing to say about it, but is that they admit that the provincial plenary power at some point must yield to the rights holder. And the way that they differ from the dissent is that they say that that point is substantial interference. But they also acknowledge that the question of a substantial interference is a factual and contextually specific exercise. And I think practitioners will continue to push the court to say that in situations like this, that there was a substantial interference. We have clarity that this is the test that we need to meet. And we can continue to debate whether changing the framework of an election in August when the election is in October, or changing it on September 28th, like which is where the substantial interference lies. But I do think that they have changed the test and clarified it in some respects.
So to just jump off on that, from a practitioner's perspective, how do we expect this case to impact Section 2B cases in the future?
I'm happy to jump in on that. And then Geeta and Professor Rymer, obviously, if you want to jump in, please feel free. But from a practitioner's perspective, as Geeta's already said, the Bayer framework it's going to be much harder to establish violations of Section 2B under this framework. Also, as a practitioner, arguing the positive and negative right aspect is very complicated, and that's actually something that Justice Abella picks up on in her dissent, which is that it can become a bit of an absurd game in a lot of ways when you're trying to identify positive and negative rights. Because ultimately, at the end of the day, and as Justice Abella points out in the dissent, almost any state action you can argue either way on almost any state action. So it's, I think, as a practitioner dealing in Section 2B, one of the things that's going to be so important going forward is how the state action is framed. And it's going to be on practitioners and on the lawyers who are advancing the argument that the legislation infringes freedom of expression. It's going to be on us to work really hard on framing that argument so that we fall within this framework that has up until now been limited to a very small section of Section 2B cases. And now we're going to see a big expansion in that. So we're going to have to adapt and learn how to frame it properly so that we can actually succeed in these cases going forward.
Thank you. Yes, and the majority seems to pick up on this analogy of comparing positive rights to, providing a megaphone, and negative rights as, prohibiting a gag. But it's not really clear how far that analogy gets us in more complex cases like the one here. So did we find that the court provided any clarity on the distinction between positive and negative rights? You touched on this in your answer, but I'm wondering whether...
I really have to say that they did not. I am still confused. I think, in rereading the decision today, I looked at paragraph 30 of the majority's decision, where they try to explain why they see it as clearly a positive rights case. And they say that the remedy that the city is seeking is for the province to act by enacting new legislation or repealing the impugned provisions of the act to restore the previous statutory platform. And they say this reveals a straightforward positive claim. And from my perspective, I still don't understand, because I think what the remedy that is being sought is for the court to strike down the impugned provisions as invalid. And that is the remedy being sought in a negative rights case as well. And, it was not the province which set the number of wards previously at 47. That was a power which the city had to create and to determine the number of wards. And so even when they say it's a straightforward positive claim, I still see it as murky and as very challenging to determine. And that was, the CCLA's primary focus on the intervention, was to say, this is the only right where we have two different tests, depending on whether we say it's positive or negative, and why do we need to do that? So to the previous question about the impact on practitioners, I think that one thing we may see is a greater focus in situations like this on advancing claims under 2D or advancing claims under Section 15, because the majority carves out the 2D scenario, and they actually say, we're not opining on whether the Dunmore test still applies in 2D, because one of the submissions that we made was that in Mounted Police, the Supreme Court did not apply Dunmore, which was arguably a positive rights case. And also in Section 15, we have the same test, whether it's positive or negative rights, and we know that there are positive rights. So, at first instance, the 2D claims and the Section 15 claims were made before Justice Belababa. They didn't succeed because the case, I think, was primarily framed as this issue of free expression. But where there are those impacts on those other charter rights, I think that there may be a recasting of claims, because the tests are frankly much easier now.
Absolutely. So from an academic perspective, Lorraine, do you see any different impacts that this case could have on 2B moving forward?
Well, I'd like to make a point about the positive and negative rights, because one of the things that's distinctive about the majority judgment is it really abstracts away from the actual facts of the case. And this may be in part because the actual litigants, the people who were involved in the campaign as candidates and other participants dropped out. And so it was left to the city to carry the constitutional challenge. But the dissent, I think very carefully and with sort of great precision, highlights how the change in the wards affected these particular candidacies, and also notes that a huge number of candidates didn't continue because they couldn't, and she went into the detail, somewhat into the details of the change in the campaign financing, and the fact that the change in the wards changed the issues of the campaign, because there are no political parties at the municipal level. So the candidates have to sort of choose a ward in which their talents and personalities and life history and aspirations and values match the ward and give them a good chance of success. So the technique, these techniques of really not looking at the facts and not really looking at the impact of the legislation meant that there was an easier path to imposing this positive negative framework. But what I think the issue should be is, what was the claim before Justice Belababa at first instance? Because I think the point is well taken that it was a question of whether this new legislation was valid or not. And if it was invalid, then as Justice Belababa ordered, the first election framework would continue. So to superimpose on that, this positive or negative rights framework doesn't make a lot of sense. The city isn't complaining of a gag. The city, and nobody was complaining of a gag. There was no content issue. But then this question of a megaphone. Well, an election platform is hard to analogize to a megaphone. But if you use that image, then what you're saying is there's a certain period of time in which you can't take away the megaphone. And because the megaphone is your permission to be involved in a very special individual and relational engagement in freedom of expression. And this, what Justice Abella describes quite well in the dissent as a reciprocal relationship between the candidate and the voter. And we stress this in our submissions for the Asper Center. The positive negative framework isn't sophisticated enough or complicated enough to deal with the fact that the government has created what is essential for a democratic election, the rules for the election. And the election has a duration, a beginning and an end. And this engagement of freedom of expression is cumulative and developing and reaches its crescendo on voting day. And so the idea that you can't take away the megaphone in the middle of this freedom of expression process, which, as I mentioned before, is crucial to the whole idea of a democracy, seems to be a special category. And so we have a failure to look at the facts, which facilitates, I think, a very superficial application of a test that's inadequate to deal with the actual freedom of expression issues that are in play.
So the evidence is an interesting aspect of this appeal. It's interesting to note that Justice Abella's dissent does discuss some of the evidence about the actual impacts on candidates themselves, but the majority decision does not. So Gita, what role did the evidence play in this appeal, and why do you think it had an impact on the dissent but not the majority?
So I guess to go back to the beginning of the case, it was brought, yes, by the city, but it was also brought by private individuals, so candidates, electors, and also a group called Women Win TO, which was a group which had been planning, I think for more than a year for this 47 ward election and how they were going to get more women elected. And so there is like very detailed affidavit evidence, which my firm actually, before the Superior Court, acted for some of the applicants. And so we were involved in getting that evidence before the court. And it really, I think, even for me, like my introduction to the case was just hearing constitutional professors opining on Twitter that, there's no way that this case is going to succeed. But once you actually spoke to the candidates and heard what they were going through, it was really surprising. I think, one of the affidavits, which is described as the affidavit of Megan Wilson, and she says, I can't even speak to people about issues in my ward because we're just talking about Doug Ford and we're talking about provincial politics, which, have nothing to do with the actual issues in this election. There's another affidavit from Chiara Padovani, which speaks about planning. So there's, huge restrictions on what a candidate can do before the commencement of the campaign period. And what she says is, yeah, you can't say I'm running for this ward, but you can plan and you can get to know the ward. And she says, I know where everyone wants a new speed bump in this ward. I made it my mission to understand this ward. And I don't have that knowledge or that understanding of the other ward. And I think that evidence and the local, hyper local nature of municipal government, combined with like the expert evidence of Professors Valverde and Professor Semiatiki, it really came out in Justice Bellababa's decision. But then as the case has progressed through the appellate courts, I think, as Professor Weinrib says, as the applicant settled because the election proceeded on the 25 wards, that focus has been lost. And we come to a point where the majority says that, this isn't a substantial interference because we have shorter campaign periods in federal and provincial elections, which completely misses all of the evidence in the record about why a municipal election is such a different creature and such a completely different thing than a federal and provincial election. It's hyper local. It's based on name recognition, incumbency. You don't have the benefit of party recognition. You don't ride a wave and get elected as just based on the popularity of your party leader at a certain point. You're really just going it on your own. And so preparation, the fact that people prepared for years is so significant in a municipal election. So I think that, of course, that factual and contextual nature of how the inquiry should be conducted under 2B is so well set out under the Irwin-Toye test. But I do think that there is room to push that kind of analysis in this new Bayer framework as well.
Lorraine,
if I could just jump in on that, going back to one of the things I was saying before in terms of the framing of the case and what as practitioners we were talking about could happen in this case as it went up to the Supreme Court. There were several ways that the court could have gone with this, and it's clearly an intentional choice to advance this positive negative rights framework, which was facilitated by the fact that the majority could sort of step away from the facts and make this a far more framework theoretical case in terms of what the majority wants to see for Section 2B going forward. And as Geeta said, when you keep it in the Irwin-Toye analysis, that's where the facts really do become so much more important, which is exactly why Justice Abella's dissent is so much more fact specific and dives into these other issues. One of the facts that was critical for the Asper Center was on the timing of all of this activity, and the fact that the legislation was passed at literally the 11th hour and changed the nature of the rest of the election at in the middle of the campaign period of the election period. And that fact, the timing aspect of it, gets totally lost in the majority's decision. But again, that's central in Justice Abella's dissent. The fact that this happened when it happened was central to so many parties and interveners. It would have been one thing if this legislation had passed a year and a half before all of the election activity took place. But the fact that it happened when it happened, after the nomination period had closed, during the campaign period, that really was fundamental and central to so many parties, including the Asper Center, because that's when people are in their limited time frame that they have fully engaged in electoral expression. And it's not just the candidates. And again, that's something that got lost through when the facts were divorced out of the majority's decision, is we're not just talking about candidates, we're talking about all participants in the electoral process. We're talking about the voters, the media, everyone that is engaged in a municipal election. There's freedom of expression issues that arise for all of those people. Freedom of expression, of course, is not just the right to say what you have in your mind, but also to receive that information. And so the freedom of expression rights of people who want to receive information, want to participate in the electoral process, those rights were all put at issue by the legislation. And the majority really does step away from analyzing any of that. But again, it is front and center in Justice Abella's dissent because of her interest in keeping it in the Irwin-Toye analysis.
So why, and I'll direct this to you, Lorraine, why do we think that the majority, other than their sort of glossing over of the evidence, why do we think they weren't persuaded by the timing component of it that was so forefront to Justice Abella's dissent?
Well, I think that this is part of an approach that has been developing slowly in the Ontario Court of Appeal and some other appellate courts and in the Supreme Court, which seems to be a reaction against the very broad and deeply normative transformation that the Charter has effectuated in Canada, and properly so, in my opinion, because that was the purpose of adopting the Charter, and that was the basis of the political controversy about the Charter, and produced the ultimate compromise of rights, strong normative protection of rights, narrow, also normative to my mind, justification of limits on rights and the override. But I think that what we have here is a general pattern, it's part of a general pattern of diluting the rights. I have often described when I teach Section 2B that we sort of have had until this bare alternative analysis materialized. We had kind of a highway with no off ramps, as a direct highway to Section 1 in Section 2B. And now we've got an off ramp created, but this is developed in almost all of the sections of the Charter, that the normative simplicity, which I say positively, not negatively, the normative clarity of the purposive interpretation has made it relatively easy for strong rights cases to get to Section 1, as it should be. And so I think there is a bit of a movement to try to make it harder to prove the right and its infringement, because the government, in the minds of some judges, I think, the governments were having too much difficulty establishing justification under Section 1 and winning the case. So I think that this is a general kickback against the Charter, a general reduction in the transformative effect of the Charter. Now, if it has to be done at the cost of looking at facts, and we'll look a bit later, the cost of looking only at the Charter text and not using constitutional principles to fully, and not only animate the text, but fill in all the gaps and update the text, then we're on a very different trajectory than we were before, that this marks a real turning point. And so we can look and focus on the facts, or look and focus on 2B, or look and focus on the positive and negative rights issue. But I think that it's possible that there's a larger pattern. And I think the strength and cogency of the two dissents in the Court of Appeal and in the Supreme Court of Canada support my position that these are radical changes.
Thank you, Lorraine. So I want to ask you about unwritten constitutional principles, but before I do, does anyone else in the panel want to add anything about 2B to the questions we've discussed so far? Okay, so Lorraine, what do we make, how are we to use unwritten constitutional principles moving forward? Has anything changed as a result of this decision? And if it has, how much? How much has it changed?
Okay, so speaking concretely, the court, the majority considered that it had to make a ruling on whether one can invoke constitutional principles absent the text, and I'll sort of to speak a little bit about what it means to say there's no text. But can you use constitutional principles as the main platform for invalidating statute? Okay, so that's a very concrete kind of question. I can't say it wasn't raised here, but I actually think that if constitutional principles have been used properly, we would have been in the Irwin-Toy framework, and we wouldn't be in this off-ramp of Bayer, and the incredibly important constitutional principles of democracy and the rule of law would have made it very clear that freedom of expression had been breached in its core guarantee in terms of democracy and not retroactively changing in progress election. But in deciding this fairly narrow question about whether freestanding constitutional principles unassociated with constitutional text could invalidate statute, the court has also done something I think that is much more significant, and we'll have to see what happens in the future, since clearly Justice Sabella did her best as a strong judge in terms of supporting the development of the charter and the idea of the living tree of the Constitution. What's really at stake now is what constitutional text means. Now, let me point out, in this case, we didn't have to go to the question of unwritten constitutional principles, to my mind, because democracy and the rule of law, which are the main principles at stake here, are in the text. The preamble to the charter affirms the rule of law. Section 1 affirms that the justification for infringing rights must be consistent with the idea of both a free and democratic society. So there was no need to invoke unwritten constitutional principles, because the real principles that were relevant are actually in the text. So again, it's like saying the majority didn't really take the facts seriously. These are very odd ways for the court to be carrying on. So that's one thing. Now, the problem with saying we have to rely primarily on the text is that, unlike many, many other countries, and we may be unique in this, I'm not sure, we have the idea that we have a written text that should be primary, but we have a text that is fragmentary and in many places completely outdated. And we have the charter, which is a modern Bill of Rights associated with the international human rights system, and sort of grafted onto it. So to say what we have, what's text and what's principle, and what the relationship between the text and the principle is maybe the most important question of our future constitutional life, because if we don't use constitutional principles to interpret the text forcefully, and we don't see the constitutional principles as providing, in some instances, the most important framework of our constitutional order, then reliance on the text is going to push us back to, well, maybe the 20th century, but maybe earlier. The Constitution is really inadequate to the way government in Canada operates now. And so this push by the majority to dispense with the primary importance for us of reading the constitutional text as based on constitutional principle, but also seeing that the very framework of the Constitution derives from these principles, and that the text is incomplete and the text is outdated and outmoded. That seems to be our best way forward. And the majority judgment is putting us on another track.
So to jump off on that point, the majority does rely on something that is present or absent in the text, which is that municipalities don't have independent constitutional status. And the majority, says that the provinces essentially have unfettered discretion to do what they will with municipalities. So, Alexi, I'm wondering what this decision does to the impact on the relationship between the provinces and the municipalities, and whether it could impact municipal elections going forward.
So again, similar to what was just discussed in terms of the unwritten constitutional principles, the role of municipalities was something that really could have gone either way in terms of the focus of the court, and there was some very strong advocacy that was provided in terms of the role of municipalities and the purpose and place of municipalities going back through history, going back to Confederation, and the very important role that municipalities play in our democratic structure. And on the other side, the province at the Court of Appeal and very expressly at the Court of Appeal argued that the province has the power unilaterally to control the fate of the municipalities, and that the province could disband municipalities, let alone municipal elections, if it felt that if it wanted to do that through legislation, it has that power. And that is something that is picked up here, and it does have broad sweeping implications for municipalities and the power of the province over municipalities. And that is, again, something that picked up on through not just the unwritten constitutional principles, but directly saying that the way that the Constitution is to be interpreted does rest a huge amount of power in the provincial legislature to control the fate of municipal elections. So I do think that there is a strong likelihood that we will see this type of power used going forward in this. I don't know if it's necessarily going to be in this type of situation with an election type of issue, but I think that we will see this power being used by provinces because the Supreme Court does grant a huge amount of power to the provincial legislature. And I think, as I said, there was very strong. There was an intervener in particular, the Federation of Municipalities, that did an excellent job in discussing this very important historic role of municipalities throughout the history of Canada. And I found it very persuasive. It was an aspect of the litigation that was a great role of an intervener, and it was just not picked up on by the majority at all.
So I'd like to could I just jump in just for a second? I think that this is an example of how the text can be used. So Gita went through some interesting material on the facts, which one of there was an emphasis in the way the facts were developed. And I don't know whether this was intentional or not for the purposes of invoking constitutional principles, but they did invoke the distinctive multiculturalism of the city of Toronto and the challenges of electoral representation at the municipal level of such a multifaceted, diverse community, but also the question of municipal services and their incredible importance in women's lives. And so we have interpreted and other provisions in the charter which emphasize those elements for the purposes of interpreting freedom of expression in the political and electoral context. But of course, if the majority is going to both elevate the text and demote constitutional principles, we're going to have to look at how to parse all these elements of the charter that we haven't used as strongly as we could in the past. And the other important element is Justice Abella's comment about the living tree. We need the idea that the Constitution evolves to respond to the reality of Canada and the particular challenges we have in terms of rights protection and other challenges by not using this 20th century or 18th century or 19th century historical origin of the charter text, and constantly seeing how we can abstract from it and modernize it. And the question of the status of municipalities, and particularly these very diverse urban municipalities, which present so many problems in the transformation of work and the need for public services so that women can be equal citizens. And I think all of that is available to us, but this majority judgment suggests that we may not be as successful in those approaches as we have been in the past.
So we have a question from the audience that seems to me to fit in well with what we're talking about here. The question is, do we expect this decision to impact upcoming litigation on the Ontario third-party election advertising restrictions? And I'll open it up to the floor to whoever feels like they want to answer that. Do we expect this decision to have any impact on the upcoming legislation on Ontario's third-party election advertising restrictions?
Well, I could make a comment while other people think about what they'd like to say. The case applies to provincial elections and the provincial election, and the provincial elections do have special protection under Section 3. But if the court is going to be strict in interpreting the language of Section 3 and not invoke a strong purposive analysis filled with references to constitutional principles, then the challenge is unlikely to be successful. There is this purposive interpretation, for example, that has read in the idea of effective representation in Section 3. But of course, it's not text-based. And it does draw on constitutional principles in ways that I think the majority in the City of Toronto case is not open to invoking. So the questioner is right to say that the very close split of the Court of Appeal and the Supreme Court of Canada in these cases suggests that we've got very different pathways in our future, and whether the majority in the City of Toronto case prevails will affect every element of the analysis in that case, just as it affected every element of the analysis in the City of Toronto case.
Thank you, Lorraine. Anything to add from Alexia or Gita?
I'm going to refrain from commenting because my firm is counseling that challenge as well. But, I think I will say that from the claimant perspective, you always do better when the court is focused on the facts as you have framed them. And so, I think that is kind of a positive sign for anyone doing this type of litigation, that the decision which was more focused and engaged with the facts was the dissenting decision. But I'll just leave it at that.
Thank you. So we've been dancing around the subject, but I want to ask the panel, and Lorraine, perhaps you can get us started. What can we take away from the clear split on the bench in this decision?
Did you want me to?
Yes.
Yeah, okay. Well, we've had tight splits on the court and before, but this is so methodologically dense in terms of the space between the majority and the dissent. And also we have Justice Abella writing the dissent and now retired. And another appointment from Ontario coming up when Justice Moldaver retires, which I understand will be soon. So I think it's very hard to predict what will happen in the future, but there's clearly a philosophical almost it's a very theoretical, it's a very deeply rooted fundamental split in the majority and the dissent. And it seems interesting that it's coming almost exactly at the time that the charter is coming to its 40th year. And so maybe in the cycle of adopting a Bill of Rights that is very contentious and where certain provinces opposed and where certain approaches to interpretation and abstractions and principle and international human rights law and all those kinds of things, all those were in controversy and certain positions were accepted and certain positions were rejected. Maybe in the life of a Bill of Rights like the Charter, this kind of kickback or adjustment of the approaches to bring in what those who oppose the Charter had as their primary concerns and into the picture. Maybe this is a natural progression, but I think that the division is very significant. It's not something that's related just to this case. It's not related just to Section 2B. It's not just related to the rights. I think it has to do with the judges finding Section 1 justification too difficult for governments to succeed on. I think there's a resistance to international human rights, and there's been a majority decision rejecting or disdaining the Supreme Court judges making reference in their analysis to comparative constitutional law. So, and it's not by coincidence that decisions like that will favor provincial power or favor interests that are inconsistent with the interests of the populations of the large urban centers. You know, we know that these are the political patterns in Canada. So I think that this is a split in the court that we should study very, very carefully. And that's important for practitioners who have to make choices in how they present their cases. And particularly how they can get the facts in, because it's hard to see how this majority judgment would have been written if there had been strong fidelity to what had actually been submitted in the factual record as affirmed by the first instance judge.
I completely agree that this decision shows you used words exactly that I would have used, fundamental, foundational, philosophical shift and split in the court. And I completely agree. Practitioners are going to have to figure out how to frame these arguments, not just for the Supreme Court, but for the Court of Appeal as well. I mean, there was a philosophical, fundamental split at the Court of Appeal as well. Similar type of just a fundamental view of how to interpret the charter, and how we're going to proceed with charter litigation going forward. And from the majority from the Court of Appeals to the majority of the Supreme Court, a very textual, literal approach to the charter and to how that's going to be interpreted, versus again, that, as Professor Myra has been saying, the purposive living tree type of approach. And it really is just a purely fundamental philosophical approach to how the charter is going to be litigated going forward. So there, as I've said a couple times, there was a discussion of whether or not the Supreme Court would take this case and make it this opportunity to make a pronouncement on how the charter is going to be interpreted, and they did. So now we have this pronouncement, and now it's up to us as practitioners to see how we're going to approach litigation going forward.
Thank you, Alexi. So we can open up the floor to questions from our attendees if anyone wants to write their questions in the chat. While we're waiting, I'm going to get us started with another question. So and I want to open this up to everyone on the panel. What were your impressions of the bench during the hearing of this appeal? And did those impressions map onto the decision?
I'll start. Yes, the bench. So it's one of those things, when I'm teaching or coaching or mentoring, you often say you can't get a sense from how the bench behaves during a hearing or how the judge questions you. Just because you're given a really hard time doesn't necessarily mean that that's the way that the judge is going to come down in their decision. But in this one, the panel definitely telegraphed, and there was even debates between judges happening during the hearing. So Justice Abella and Justice Brown were definitely debating each other during the hearing. So it was a very fun hearing from constitutional litigator perspective, because the bench was super engaged. And as someone who always enjoys questions from the bench and bench interaction, watching that and being part of that was wonderful. But they certainly did not hide their thoughts and beliefs during the hearing by any stretch.
I mean, I would say, as it was my first time appearing at the Supreme Court. I've never actually been there because it was a virtual appearance. It was terrifying that that there was kind of an argument between the two sides, I guess, on the appeal. But I think the most interesting and challenging thing was the Chief Justice's silence, because there wasn't really, I don't think he asked a single question. And so it was difficult to gauge which side he would fall on. And it became clear to me that he would be the tiebreaker. And we know where he landed, and we know that he authored the majority. But, with Justice Brown, it's the questions that he asks you, I don't find them to be hypothetical. I find them to be him, giving you an opportunity to convince him of your position, and he kind of states his position to you. And I think those are the best kinds of questions that you can get from a judge that like I go in there for the CCLA. I know that Justice Brown is not going to be convinced by my position on this appeal, but that, I would like him to understand it. And so he does engage with you in that way, but the Chief Justice just complete silence. And the moment we got the decision and I saw, okay, like a Bella dissent, and I was just like, okay, we know what happened here.
Yeah, we had said for ages, all we need to do is see who authors majority versus dissent, and we'll know what ends up happening with this. And it was really just going to be a matter of vote counting. to see where it all lined up. But I completely agree. Wherever Justice Brown fell, wherever Justice Abella fell, then it was just going to be a matter of counting after that.
I'd like to jump in. One of the things that I'd like to say to those who are watching is that the Court of Appeal oral argument is available on the Court of Appeal website. And of course, the Supreme Court of Canada oral argument is available on the Supreme Court website. This is an unusual opportunity to see a case argued at two different levels at your leisure. And I think that since I have taught constitutional litigation and constitutional written and oral advocacy during my career, I think that it's just a wonderful learning tool you see very active, very well prepared judges dealing with such an incredible array of constitutional issues that are all interwoven and in a sort of coherent pattern in each of the judges' minds, but it's being just sort of tossed around in these sort of question and answer interaction formats. So it's really fascinating to think of this case as something to learn about written and oral advocacy from. That's one point. But the point I want to make is I thought it was that in the Court of Appeal, one of the most important things was Justice McPherson's, who was presiding, characterizing the provincial election as dropping an the provincial legislation as dropping an atomic bomb on the election. And I thought that was the moment where one understood that this judge really knows what happened here. I mean, he lives in Toronto. We went through the experience of not only the election starting and then being effectively canceled and the new election being superimposed, but also the fact he said that the government should have understood that there would be judicial review, because the government lawyers seemed to be suggesting that a lot of the chaos was created by the fact that there were charter challenges. So the tone in the Court of Appeal was quite interesting. In the Supreme Court, one of the things I thought was very interesting was that I felt not only the judges were very well prepared, but there was a real learning curve going on as the argument progressed, that the judges seemed to be taking up each other's questions and trying to get all the pieces of the puzzle to fit together. And I've rarely seen that in a Supreme Court of Canada oral argument, that that there was so much to learn from in terms of what judges are doing when they work through such a complex case and try to see what the coherence is that they have to provide between the different parts of the case, and getting it. So many of the judges did participate multiple times, so that you could see the growing sophistication in the questions that they were asking, and their deeper commitment to a position on one or more of the issues. So I think the case is important for that too. That I think the judges saw that there was a lot at stake here as the oral argument progressed.
I guess just to add to that, I think what's so unique about this case is that it has been brought by the city and by originally two or a few distinct groups of claimants, which each had their own argument and their own lens on the case. And I think that's kind of unique in terms of constitutional litigation, because usually you have, one set of lawyers kind of defining and driving the case. But this issue just attracted, it affected so many people in the city of Toronto, and it attracted such an interest that there was kind of this like bombardment of like anything we can do to get this legislation struck down, right? And it happened so quickly. And one thing I remember from like being in Superior Court before Justice Belobaba was that, you know, he was hearing about unwritten constitutional principles, he was hearing about Section 3, he was hearing about Section 2B all in a day. And he had so many factums filed before him. And we had been there, I think it was like at 4 p.m. We had been there, you know, for like 8 hours in this huge courtroom. And my colleague Stephen Barrett was like arguing the 2B issue. And Justice Belobaba said to him, so I think what you're saying is that there's an issue with the timing of the legislation. And I just thought, oh my God, we've been here for so long. And he's just understanding like this argument now, like we're doomed. But I mean, he did, you know, end up finding on that basis, but it's just, you know, we think of it as the way that we frame the case, but it's a real insight into what a judge has to deal with when there are so many parties with completely different arguments coming at them. So I think that's also a very unique aspect of this case.
So we have a question from one of our attendees. We have two questions, but one of them flows nicely from what you just said, Geeta, which is, you know, the fact that this case garnered a significant amount of publicity and it invoked a lot of strong emotions. How do you think that attention and emotions, you know, whether that be shock, anger, maybe even a sense of unfairness, how did that impact the litigation and possibly also the legal analysis at the Supreme Court?
You know, I have to say, I definitely see that as the framework through which judges approach this case. And in some ways, I think it's because if you were a judge in the city of Toronto, you were also affected by this and you kind of lived through it. And so I think when we talk about how the majority and the dissent, like, they don't really seem to be speaking at each other, and they seem to be speaking at each other rather than speaking to each other and focusing on different aspects. I think it's because this case provokes a very emotional and visceral response of you either think it's unfair or you just think, okay, the province can do this. And then you frame your legal analysis to sort of fit with the conclusion that you've arrived at. And in some ways, I think it's much more like arguing a case to a jury than it is arguing a case to a judge. Like, it was just so visceral, and the kind of energy that was in the courtroom when I was there at Superior Court and also in the Supreme Court, I think is just so unusual for a constitutional case.
Okay, I think we have time for one more question. This is from one of our attendees. So if the tide is turning towards a textual, strict interpretation of the charter, as the majority decision in this case indicates it might be, aside from focusing on the facts, which we've already discussed, what should rights advocates and rights holders focus their attention on to further a purposive interpretation of rights? And that's from either an academic perspective or a practitioner's perspective. Does anyone want to jump in on that?
So I'm sort of thinking of this from two different perspectives. I mean, there's the perspective of the parties, and then perspectives of interveners as well. And as someone who acts for interveners on a regular basis in constitutional litigation, they may be slightly different. So from a practitioner's perspective, or the party's perspective, it's even when we're looking at a very text specific literalist approach, there's going to be different ways of approaching it. So from the literalist perspective, it's going to be a matter of framing the case and fitting within that framework, or depending on the case, even in the majority decision in this case and in some of the other decisions, they're not fully watertight. So there are abilities to frame it and find the exceptions and distinguish cases. So there's going to be strategic choices that need to be made from the party's perspective about how you fit into the framework, or if you try to argue from a perspective of trying to fit into the exceptions. That'll be a strategic choice to be made as parties. From interveners' perspectives, I think that interveners will have a greater role to play going forward to, if possible, depending on the institution or the organization that wants to intervene, to try to shift litigation and to provide the court with additional frameworks and a different approach, even because as an intervener, one of the wonderful things as an intervener is that you can argue from a purely theoretical framework approach. You're not necessarily as tied to the ultimate outcome. And sometimes interveners can put forward arguments that are not likely to succeed, may not succeed, but it's all sort of the long game of trying to advance the approach that a court might take, and trying to guide the court, trying to provide assistance to the court going forward. So from the intervener's perspective, there's going to be a lot of opportunity to advance those arguments and to keep trying to push at the edges for these arguments going forward. And as I said, as someone who acts for interveners a lot, I have in the past, in other cases, put forward arguments that were not necessarily likely to succeed, but were part of the advancement of the principle that the intervener was trying to put forward.
Okay, if I could jump in, I think that the applicant side, the side that the Asper Center intervened on, would have won if the parties had still been in the case when we got to the Supreme Court of Canada. I think we would have gotten one more judge, at least. And I know that in the Court of Appeal, the lawyer for the province asked for a very, very large award of costs. And it would have been prohibitive for people who had just spent a lot of their expended their own resources and also their time in running through more than half of an election and then having to drop out with nothing for it. So I think that we need to change the rules about costs in these cases that are sort of public interest advocacy cases, and also perhaps coordinate the work of interveners a bit more when you have this strange situation arise where the parties aren't there, and once members of the court are clearly resisting the need to actually focus on the factual record. So, I mean, that's a difficult thing to actually take on, but I think it has to be taken on. In terms of argument, 2 paragraphs from the Asper Center factum were quoted in the Court of Appeal and in the Supreme Court. And I wrote both of those paragraphs. And I got the ideas from international human rights law and comparative constitutional law. The European Convention is incredibly good on what is a genuine election, what is this reciprocal relationship between the voter and the candidate, and what the progression of the electoral period produces in terms of the political, electoral freedom of expression engagement. I got it all from there. Now, the court has said it doesn't want to hear about comparative constitutional law, but you at least have to rigorously research the international material, and you can cite the international human rights law that's applicable to Canada. And you get a huge amount of normativity there, which is grounded in something other than what some judges would think is just an improper use of constitutional principles that aren't in the text. All this emphasis on the participation that freedom of expression affords in the electoral period, which is in the Canadian cases, but the majority of North comes from the international material. So I think that it's very important to read widely and see what rich resources there are for making rights arguments in whatever context you're in, and then using the constitutional text we have, these, the multiculturalism clause, the gender equality clause, the preambles of the old constitution and the new constitution, use all that material. I also think that it is very important to make sure that the factual record is the best one that you can put forward to build your arguments on. I think the factual record here was not only sort of amazing and impressive. I think that it was also, in a sense, impossible. I don't know how that record was created in the time frame, but everything was there. It was just a phenomenal resource. Usually the problem is that the facts aren't good enough, or the facts weren't presented well enough. And so it's the idea that this case produced such a sharply split court with a great factual record, which the majority didn't look at, is something we should heed for the future in terms of how we construct and argue these cases.
Thank you so much. We are at time, but I want to extend a huge thank you to our panelists for all of your insight today.
Thank you, everybody, for joining us, and thank you to our panelists. I want to thank again Professor Weinrib for both the assistance that she gave to the Asper Center in the case. I also want to acknowledge a fair bit of contribution and work that was contributed by Professor Yasmin Dawood, who was not able to be with us on this panel today, but she was also very much part of the team, and Alexi and Little for representing the Asper Center. And thank you, Geetha, for bringing the perspective that that you brought to the court, to our panel today. So I think that there's really a lot in this decision, and we're starting to see it play out in some of the other decisions coming out of the court that have similar splits. And we'll be watching going forward. Thank you so much for today.